Continuing this theme about the most important issues in probate, why is probate taking so long in the state of Florida? Oftentimes the answer is the lawyer. The lawyer isn't doing the job. The lawyer's not processing the paperwork quickly, but sometimes it's the client. The client is not producing the paperwork quickly in a timely basis that's required in order to get the case moving along. What we have to, and there's also the circumstance where the court is not moving things along. But to be completely blunt, even though courts across the state were having a horrendous problem getting hearing time, that's largely not the case in the probate divisions of probate courts. We deal in circuit courts all across the state. Getting hearing time is a real problem. Sometimes it's months out to get a 15-minute time, a 30-minute hearing time. But by and large, that problem does not exist in probate courts. With rare exception, if we need to get a hearing on something in a probate case, we can pretty well get that hearing fairly quickly. Now, probate is largely a paper-driven process. That means that there's lots of stuff that we need to do on the front end in order to put a package together to get it filed. Oftentimes, chasing down that client to get the paperwork is where the delay is. Now, one of the other secrets about what's happening in the state of Florida that's really problematic is that every single circuit has a completely different set of paperwork. Again, part of the inside baseball, the underbelly of probate is that one circuit has completely different requirements from another circuit in terms of what the check boxes are for that paperwork. And that is confounding, I guess, from a lawyer's perspective, because the reality is the law is the same all the way across the state of Florida. So whether you're in Pensacola or Key West, Miami, or Orlando, the law is the same. The Florida probate rules are the same. So why is it that every clerk, and frankly, sometimes judges within the same circuit, have completely different requirements? And that's one of the things that is very frustrating, I guess, from the side of the lawyer's perspective, because you get, a clerk, you got a secretary that's been doing this forever. We do one thing exactly the right way in one judge, check the box, get the paperwork in, and then a judge, again, in the exact same circuit, will reject that and kick it out because that's not the way that judge wants to run that judge's courtroom. That's the judge's prerogative. That's the clerk's prerogative. Although, quite frankly, sometimes the judge isn't even aware of this because we got clerks that are the ones that are navigating this process. But that's what probate is. And so I can only tell you that in this office, what we have endeavored to do is to be mindful of what the judges require, what the court requires, and we chase that little rabbit down there. I'm looking at this image on my screen, and we chase that rabbit. We chase that process. We do everything we can to move that case along just as quickly as we can and mind our duties and obligations to the court. If you're involved in probate, we want to get that over as quickly as we can, get it distributed for you. We want to work with you. If you have questions about this, please drop a link, ask us questions.